Can you explain the state's perspective the significance of Exhibit F?
From the state, so the significance
What is Exhibit F?
Okay, so it means nothing. It just means that the defense counsel easily could have found this witness had they wanted.
What is Exhibit F? Is this material that the state had that would have been discoverable that was not disclosed?
No, so this is just material from defendant's QuickBooks that we, we're just looking through. It's an audit of all the transactions.
Why wouldn't that be in an open discovery state like this, under 313.3? If that existed at the time of trial, that audit trail, wouldn't that be discoverable?
Not necessarily, because they are defendant's own records, but it's not discoverable because it does not actually matter, because the person...
Is that a test of discovery, whether it matters?
No, it's whether it's material or exculpatory.
Or could lead to discoverable evidence, admissible evidence. Let me just ask you, would that, if you had it right now and we're going back in time, and there is an audit trail that the state has conducted and it's reduced to a document, would that document be turned over in discovery as a routine matter?
Not if it came from defendant's records.
But you keep referring to it being defendant's own records. Isn't it the institution's records that we're talking about, these QuickBooks, et cetera, as opposed to its personal financial records? Because doesn't he claim that I didn't input any of that information into those records? I didn't do that.
That's correct, but they are the records of the school and the foundation, which are defendants. Defendant founded them. He was the executive director for all intents and purposes.
Did you turn over any discovery that was also part of defendant's records, or any analysis of defendant's records?
We obtained the QuickBooks records from the school and the foundation servers. We reproduced them back to defendant.
Why? Because it's required?
Just because here is the records we're relying on, and we turn them over.
So, right, that's completely appropriate. Why wouldn't that be true of the records that are reflected in Exhibit F?
Because they do nothing to defendant's case, or they are not exculpatory.
Well, that's your perspective that they do nothing. But shouldn't the defendant have the opportunity to determine whether it's valuable to his strategy?
Defendant had the opportunity because they are his records that he does not.
But he did not have the audit trail that your investigator prepared, correct?